DOJ is in the midst of an ongoing criminal investigation pertaining to potential violations of the Espionage Act, 18 USC 1793E, as well as obstruction of justice, 18 USC section 1519, and unlawful concealment or removal of government records, 18 USC section 2071. The former president asserts that review by a special master is necessary because the records at issue are presumptively subject to executive privilege. But even if the former president had actually asserted executive privilege with regard to any of the seized documents, which he has not, and even if he had statutory authority to do so, which is not established, such an assertion would fail here because this case involves the recovery and review of executive records by executive officials performing core executive functions. The Supreme Court has made clear that a former president may not successfully assert executive privilege against the very executive branch in whose name the privilege is invoked. And that Supreme Court president is Nixon v. GSA. Even if the former president had attempted to assert executive privilege, which he has not done, that assertion would not justify any restrictions on executive branch access. Mind you, and Asha Rangappa pointed this out on Twitter many times, that this is executive branch. The Trump v. Thompson case that went up was a contention between a former executive and Congress, which is Article 1 of the Constitution, and Article 2 is the presidency. Now, this particular conflict that is an even weaker claim than the executive privilege claim that Donald Trump had in the congressional fight in Trump v. Thompson. In this, he's going after the executive branch for which executive privilege is invoked. It is not invoked for the person who sits in that office. It is invoked for the office. It is something that Donald Trump never understood, and he probably never will. And that's all right.